My name is Dan McCauley, Director of Sales, and we're fortunate enough to have Julie Kilgore with us today. Julie is both the president of Wasatch Environmental, and she's also the ASTM E1527 Task Group Chair, and she's worked tirelessly with the ASTM committee to work on the revised standard. A few quick items before we hand it over to Julie. We are recording this session, and it will be available on demand as soon as we conclude today. We'll also have time for Q&A. To ask a question, you can either use the chat feature, the Q&A feature within the Zoom platform, or if you're not shy, when we get to the Q&A section at the end of the presentation, you can simply raise your hand and we'll be happy to unmute you. Lastly, we have a quick poll question that will show on your screen right now regarding which ASTM standard your firm is currently using. The results will be discussed amidst Julie's presentation, and we appreciate your participation. We'll let this poll sit for a few moments here. Looks like the 13 standards currently in the lead. Standards staying pretty strong at around 45% as we approach everyone's submission. We appreciate your participation. Give it just another moment. All right, we're approaching the end of the poll. Looks like the 13 standard is 43%. 21 standard is being utilized by 28% of today's participants. And depending on clients' requirements at 29%. So we'll go ahead and end the poll and we'll discuss the results within our presentation. So now, without further ado, we'll hand it over to Julie, and thank you so much. Enjoy the webinar.
Thank you. Good to see everybody. Thanks for the opportunity to come in and talk a bit about where we are with implementing and navigating the new 1527 standard. Dan, can you just give me confirmation that you can see my slide?
Yes, we can.
Looks good. All right. Well, welcome everybody. As Dan had mentioned, I have an environmental firm in Salt Lake City, Utah, and I chair the E1527 task group. I've taken the task group through the last 3 revisions, the 05, which tied us directly to the AAI, the All Appropriate Inquiries Regulation, then the 2013 that had a couple of really important updates, and then through this last revision. I also served as a member of the EPA's Federal Advisory Committee that assisted EPA in developing their All Appropriate Inquiries Regulation. And the reason that relationship between ASTM and EPA, and not the relationship, but the interaction, it continues to be very important, and it plays into some of what I'm going to talk about today as far as the status of the 1527-21 and the EPA's All Appropriate Inquiries Regulation. But the first thing that I want to emphasize are the drivers behind changes to the standard, or the drivers behind the standard itself. One thing that we have to keep in mind is the fundamental base that drives what we do with the standard is embedded in CERCLA, the Comprehensive Environmental Response Compensation and Liability Act, and the All Appropriate Inquiries Regulation. These two federal documents dictate that assessments must be conducted consistent with good commercial and customary practice. That phrase is really important. And if you look at any version of the 1527, you will see that in the very beginning, the very first paragraph of the 1527. This standard is intended to reflect good commercial and customary practice. then you take that federal mandate and then we put it into this ASTM process, keeping in mind that ASTM has no technical expertise at all. ASTM provides a platform for interested parties, producers and users and general interests to come together to agree on a consistent process that is expected to result in a consistent deliverable. That's what any standard is. So we start with what is good commercial customary practice, and then what do users and producers agree on in an effort to achieve that consistency. So when we see as a task group inconsistencies in process, when we see inconsistencies in quality, those are signals to the task group that those are areas where the standard practice can be improved. And then the other thing, of course, we have a team of lawyers on our task group. Again, we all participate in a voluntary capacity. And so the value of that brain trust in the legal and the environmental professional and the user community world is substantial. So we have lawyers on our task group that are always reviewing and looking at recent litigation and claims. And this, again, provides additional insight on where the standard practice can be improved. So these are really the primary drivers as a task group that we look to guide us as we look at appropriate revisions. So the revision process, under the ASTM umbrella for all standards, and they have tens of thousands of standards, we're just one little tiny cog in that great big wheel. All standards require, ASTM requires that all standards be revisited no later than once every 8 years, that there be some action taken no later than once every 8 years to ensure market relevance and current practices are being reflected. So this most recent round was initiated in February of 2018. So generally when we're about 5 years out, if no action has been taken yet, nothing has necessitated an urgent change. At 5 years or so, we'll open it back up and see what might need to be done, right? We have a couple of options. We can just let the standard sunset because there is no market relevance. But of course, we know that's not the case with the 1527. We could all just convene and agree that there really isn't anything that needs to be changed, that it's all working well and there's no need for change, and then just reballot the standard as is. Nothing is that simple in the 1527 world. So we pulled together our task group. We had about 250 task group members this time around, and our task group objectives were to clarify and improve existing language. So where we saw different interpretations, inconsistent application of terms, phrases, thought processes, where could we clarify and improve the existing language? It was also really important, remember, going back to those federal mandates, to update the standard to reflect what is current customary practice, what is good commercial customary practice today. And we had hundreds and hundreds of data points that helped us zero in and narrow down what that is, and I'll share those things with you today. And then, of course, to strengthen the deliverable, right? That's our output. That's the output of the environmental professional deliverable, is that report. And what we consistently hear from users is, please help make these reports better, easier to read, easier to understand, strengthen the deliverable. So those were our 3 primary objectives. We had well over 75 meetings, both in person and virtual. A very extensive industry outreach, not just the 250 members on our task group, but we encouraged our task group members to then go out into their professional circles, bring us back additional input. A lot of really good information. Now, where we are today, and I'm going to revisit this at the end of today's presentation. So the 1527 21 standard was published in November of 2021. We just barely made it. I make ASTM very nervous when we start getting close to the end of that 8-year cycle, but that was our target, right? So the standard was published November of 2021. It's available through ASTM, and I encourage everyone to, if you're going to be doing this work, you have that standard on your desktop, print it out, dog-eared, highlighted, or PDF so you can quickly search. You need to have the standard and understand the standard. I get a lot of questions, and most of the time I can point someone directly to a specific section in the standard to answer their questions. So make sure you have the standard. And I recommend reading it clean. The new version, just read it front to back without the red line. The red line is helpful to go back. It looks really messy, but some sections were changed and moved around, and that makes it look a lot messier than what it is. But it's interesting, and we do this as a task group. As a task group, we go to the existing language. What does the standard say now? Let's not change something just for the sake of making changes to words, right? We did a lot of cleanup, you read the standard as it exists clean, have that available to you. The 1527.13 now is under the ASTM umbrella, is now considered a historical standard, but there's nothing that prevents using the standard, so that's important to know. But it is now a historical standard. So once the 1527.21 was published, ASTM then now submitted a formal, it wasn't so much a request, it's a formal notification to EPA that the new standard has been published, so that EPA, that's the trigger to EPA to start their formal process to reference the new standard as being compliant with all appropriate inquiries. Now, where we are today is exactly the same place we were in 2013. EPA had issued two things at the same time, a direct final rule and a proposed rule. Now, the intention with the direct final rule was to attempt to quickly adopt the new standard. And a direct final rule is used when something is non-controversial. They've reviewed it, and it's determined to be compliant with the regulation. Same thing that was done in 2005. And if no comments were submitted, then that would take effect right away. In this case, it would have been in May. And exactly as like what happened in 2005, EPA did indeed get some comments. And so they have to withdraw the direct final rule to address the comments. So now EPA is moving down the path of the proposed rule where they'll respond to the comments, and they'll issue their final determination, hopefully sometime by the end of the year. We don't know when. There's some things that are out of the control of individuals. But again, I have to emphasize, this is exactly the same place we were in 2005. So it's not unusual. It wasn't expected. It would have been nice to have had no comments, but as soon as the first comment was submitted, we knew that what was going to have to happen. So not to panic, we're going to get there. We got there the last time, and then I'll revisit that subject when we get to the end of my discussion on what some of the changes were and give you my thoughts on implementation of the 1527.21. So let's look over some of the key changes. We have some revised definitions, again, with the intention to make the language clearer, stronger. We've added some guidance language in the discussion notes. Again, I'd said we had done some cleanup because some of the definitions had gotten rather robust and are inconsistent, and that those robust definitions are inconsistent with ASTM form and style guides. So we were trying to get some of that cleaned up, and we moved some things down into some discussion items and some notes. I think the biggest change, there's two big changes, but I think the biggest change for some will be in the historical research. So we'll talk a bit about where that came from and what the task group ultimately agreed to. There's some cleanup in the site reconnaissance, and some additional clarifications and strengthening in the report, what we're putting out, and some new things in the appendices that I'll talk about. With respect to definitions, where we have to start is what the heck is a REC, right? We're always debating or discussing that end opinion, getting to what is a recognized environmental condition. So what we did with that definition, and you'll want to make sure this gets changed and updated in your report templates. The recognized environmental condition definition has not changed. We just restructured it again to try to provide some clarity and help environmental professionals more consistently get to a similar outcome. So it's broken into three pieces. The recognized environmental condition is the presence of a hazardous substance or petroleum product due to a release to the environment. We know it's there. We have data. We can see it. The presence is an affirmative. We know that it's there. But that's not the only way to be a recognized environmental condition. So the second piece is, or the likely presence of a hazardous substance or petroleum product due to a likely release to the environment. And then, of course, the third piece is that material threat, the presence of a hazardous substance or petroleum product. We know that the stuff is there under conditions that pose a material threat of a future release to the environment. There's nothing in any of this that changes the existing definition. It is, you all know, it's the presence or likely presence of a release to the environment, right? So you know how it was all embedded into one big glob of a definition. And so breaking it into these three pieces was intended to help an environmental professional articulate there's three ways you can get to that endpoint. Now, 1 and 3 are pretty straightforward. We know the stuff is there. Where reasonable environmental professionals differ is in this likely. What is a likely presence of a likely release to the environment? And this was teased out intentionally to help, again, get more consistency in getting to that endpoint. So another thing that was added to the 1527-21 definition is a note to the REC definition. What does it mean to be likely? So there's a new note that has been added to this recognized environmental condition definition that environmental professionals are encouraged to look to and perhaps restate in their reports when they're articulating this likely presence of a likely release. And that is likely, that is that which is neither certain nor proved. We don't know it's there, but there's a reason we're looking at history. There's a reason we're looking at things that lead to the opinion of a likely release. And that's what this language is designed to help and articulate. And again, the environmental professional needs to articulate their logic and based on their logic and experience that says why you have this opinion of the likelihood of a release to the environment. So we're hopeful that that's going to help us get a bit more consistency on the outcome. Once we are well grounded in that recognized environmental condition, we were seeing a lot of misapplication of what happens when these are addressed, when these releases are addressed. And it's really not that complicated. It gets complicated on a case-by-case basis, but the overall concept of this is not that complicated. And this change occurred in the 2013 version because we had to have a clearly defined bucket for risk-based closures. But we were still seeing consultants get this wrong. And it's critically important because risk-based closures carry with them post-acquisition continuing obligations. So we got to get this right. So consistent with the revisions in 2013, just a little clarity in the language, historical recognized environmental conditions are releases affecting the subject property. We saw some people calling off-site releases these HRECs, CRECs. The release occurred affecting the subject property and it's been addressed to unrestricted use criteria. If you think no more complicated about it than that, you can eat the dirt, you can drink the water, you can lay a utility line, you can dig it up, you can put a daycare, you can do whatever you want. It meets unrestricted use criteria. Keeping in mind that every time you do a phase 1, that HREC has got to be compared to current regulatory frameworks because HRECs are not RECs. They don't meet that presence test. but those rules change and those numbers change. So every time we're doing a phase one, we're taking that historical recognized environmental condition and we are comparing that data to current regulatory framework. It's data driven. Now, what do we do with the rest of them? And this is where we see folks get them wrong. The controlled recognized environmental conditions, same thing, a past release affecting the subject property that has been addressed to anything above unrestricted use. So if you have a leaking tank site that has achieved a commercial-based closure, that's a controlled rec. If there's any management of the soil or you can't drink the water or you can't do whatever that commercial-based standard is based on, that's the control. And we saw a lot of consultants that were incorrectly putting those into the historical recognized environmental condition category, and that's not correct. And it's a significant miss. What we have to know when it's the trade-off to allowing contamination, residual contamination to remain behind. And it's fine as long as we know what it is, we know where it is, and we know what we're supposed to be doing managing it forward. And it's that third piece that buyers are getting themselves in trouble with because they don't realize that they have some due care obligations in the event that they get into, or maybe there's disclosure, or maybe notifications to the agency for property transactions. There's so many of those little nuances that only the environmental professional is going to know about. That's your role, is to bring that information to the table. And again, it's not a deal killer. That's the whole reason that the controlled recognized environmental condition, that whole reason that term was developed. Users wanted to have that indicator, yep, there's something there, but it's okay so long as. And we have to be responsible. We have to be responsible and accountable for the residual contamination that's been left behind. Because as you all know, the regulators have lost track of these things. It is this industry, it is the environmental site assessment transactional industry that is keeping track of managing residual contamination appropriately moving forward. And you need to take that role very, very seriously. So for our REC versus HREC versus CREC, if there is any residual contamination present at concentrations above unrestricted use criteria, that condition by definition is either going to be a REC because it's not fully addressed, maybe they missed a pathway, maybe the detection limits weren't appropriate, maybe the rules changed, or it's going to be a CREC, right? It's been addressed, controls are understood. If there's any residual contamination present above unrestricted use criteria, that condition by definition cannot be a historical recognized environmental condition. Now, also to help with this, the challenges around this, because as I said, it's very simple on one hand, but on the other hand, it's not all that simple. And that is the controls. How are we managing these things moving forward? So we now have a new definition in the 21 version that will be helpful for environmental professionals. And this is the property use limitation definition. This is not a new concept. When we developed the controlled recognized environmental condition definition in 2013, the 2013 states any controls, for example, property use restrictions, activity and use limitations, institutional controls, engineering controls, right? I mean, we just cast the net very broadly because there are a lot of different endpoints for these risk-based closures. Well, this go around, we pretty much agreed that institutional controls, engineering controls, those formal controls get captured within that definition of the activity and use limitations. But they don't all end in those kind of formally documented endpoints. And even property use restriction was a word that implied to some even a more substantive documented endpoint. But we had to capture the wide variety of these risk-based endpoints. And so we just modified that phrase slightly to property use limitations and then defined it broadly to capture limitations or restrictions on current or future uses of the property in connection with the response to the release that has allowed this residual petroleum product or hazardous substance to remain in place at concentrations exceeding unrestricted use criteria. So again, that's language that's in the standard. It's there for environmental professionals to help articulate the information that they're gathering, the data that they're looking at, the criteria that they're comparing to, however you need to explain that if you've got residual contamination left in place, that's a controlled recognized environmental condition. It's our trade-off to not cleaning it up to the way nature made it. So one of the new tools, one of the new appendices that we have in the new standard is the REC appendix, the recognized environmental appendix in Appendix X4. And it breaks down the recognized environmental condition definition, those three components that we talked about. And then, but then we also, we use this REC logic diagram in our trainings, and actually had developed this flow chart in leading up to 2013 to help us as a task group capture the different buckets, the different endpoints of the phase one. So it's very simplified, right, to help walk through that thought process of yes, no's that get us to these various endpoints. But the other thing that I think is going to be, I'm hopeful will be helpful, is that we put together about a dozen very simple examples. Again, they're very simple. They're not intended to capture all the world of possibilities. And I've already had some people push back on this fact set doesn't match one of the examples, so it can't possibly be a recognized environmental condition. No. We were trying to come up with at least a dozen examples that we could agree on. It gets more complicated out in the real world when you get beyond that with some different fact sets. But again, it was intended to help the environmental professionals walk through that logic and to articulate that logic in getting from a set of facts to a consistent outcome. That was perhaps the most important definition change, but there's a few others in there that you might find useful as well. Moving on to the doing pieces. On the physical setting review, we didn't change anything except we reminded you all that when in 2013 we had added the agency file reviews, again, to reflect good commercial customary practice. What were consultants actually doing? And leading up to the 2013 version, we found that consultants, for the most part, when your subject property or an adjoining property was on one of the standard database lists, especially one of the release database lists, that there was some effort there was usually some effort made in trying to review agency file records. So that's all old news, but what we saw was happening is that in the plug and chug of dropping information into the phase one was the physical setting source information from the USGS topographic map and whatever the data provider was giving them. And then over here in the government records review and reviewing agency file records for your site or adjoining property, an environmental professional was actually reviewing investigation, groundwater maps, groundwater data, and sometimes would even have the monitoring reports or the investigation reports in an appendix, and the site-specific physical information was not consistent with the assumptions, the general assumptions we've all been making for 30 years in our phase ones. They never reconciled the two. And where that got very problematic is then all of the assumptions made for all of the other sites that were in the database report were being made based on the incorrect information rather than the site-specific information. So the only thing that we added in the 152721 was just a reminder to include your physical setting source information that was obtained pursuant to the agency file reviews. You don't have to go chase it down to go get just that. But if you've got information that's site-specific because you were reviewing the agency file records, just remember to incorporate that information back into your physical setting source information and applying that to, as appropriate, to your review of all the other government records. The historical research, this one really, I think, took most of the brain energy from the task group. Some things did not change. The objective has always been to look at uses back to 1940 or first developed use, whichever is earlier. The intervals are unchanged. There's nothing in the standard that requires intervals less than 5 years. And in fact, you can go longer if the use has not changed. The standard historical sources for the most part are unchanged. The one thing that we did do is we moved chain of title, which is just who owned when. Very different from an environmental lien and AUL search, right? That's a different thing. Encumbrances are different than a chain of title report. But chain of title, which is one of the weaker historical resources, as you will see in all prior versions, the chain of title cannot be used as the only source of historical information. And of course, current customary practice, there's no one source that is sufficient for the historical. So we moved the chain of title down into one of the options under other, and we moved up interviews. And that was important to a lot of the user community and the environmental professionals, because once you move out of an urban setting, other than aerials and topos, interviews can be the most critical source of historical information. And that's a lot of transactions. So the task group wanted to highlight and emphasize the importance of interviews. So it got moved up into one of the standard historical resources, and chain of title was moved down. It's the historical research itself that we had a lot of dialogue on. Users and producers universally had agreed that additional consistent rigor was needed. Remember me telling you that we had lawyers and user groups bringing feedback to the task group. And in this world of bargain basement phase 1 environmental site assessments, historical has taken a big hit. There's a couple of places in all prior versions that use the word only, and some have taken that word only very seriously. And I will share with you that there have been a lot of very big misses because of that. So again, inconsistency in quality, inconsistency in process, inconsistency in the deliverables. That was a big signal for us that it was time to take this on and gauge what's happening out there in industry. So we needed some clear reference. At first, we needed clearer emphasis on what is the property. So properties change in time, different. They look different in the past than they look today. And that was one of the big misses that was happening, is that consultants were only looking at that address throughout time. Well, those address numbers change, and the size and the shape change, and what's next door today and is adjoining was actually part of the subject property before. So just a reminder, the subject property is defined by its current boundaries. The user defines that. User, what is the subject of the property? Consistent use of the words, of the phrase subject property. Remember that we've had some changes over time, and research of additional addresses may provide further information to meet your objective. What is your objective, right? You've got to be aware that those things change. We did some clarification in the types of use. The standard has said general information, more detailed, more specific information is better than general information, but we need specific information if the property is industrial. We've always said industrial, but we added to this. If general type is retail, industrial, or manufacturing, then additional standard resources are going to be needed to figure it out. And folks, this is all about the dry cleaners. If you've got retail, it's just not enough to tell us retail. And we added a couple of notes to try to help with this. And that is, first of all, just merely identifying that there's a building present. That's not a use. Right. So, and it says, the standard now says, for example, tenant operations in a retail building may have included past dry cleaning or other activities of concern. Right. We got to find these dry cleaners. A couple of dry cleaner information points that came to the task group. EPA shared with the task group that dry cleaners are the #1 source of new Superfund sites in this country. #1 source of new Superfund sites. This is CERCLA landowner liability protection. and they're the #1 source of new Superfund sites. We had one of the states, a consultant with one of the states in the Midwest who had implemented a dry cleaner fund, and they had to do baseline sampling on every active dry cleaner to just see where they were starting with their program. 88% of their current active dry cleaners, 88% had actionable levels of releases. And those are current dry cleaners with current regulations. And that doesn't even take into account the older ones. SBA has no time frame on, if you've had any dry cleaning operations, they want it sampled. Doesn't matter how long ago, doesn't matter how long it was there. If you had, so we've got to find the dry cleaners, and we need to do a better job of finding dry cleaners. I'm making decisions differently today about dry cleaners than I did 15 years ago. Just because it comes up on the database as a non-generator with no violations, 88%, #1 source of new Superfund sites. We have to stop pretending and finding ways to not call these out as presence or likely. Remember, likely presence. So revise the historical research for the subject property. What is good commercial customary use? When we did our outreach among environmental professionals, what do you do? What do you do? What do you do? What do you do? It's really, that's what we do. Go figure out what people are doing. And what we found through that research is that most environmental consultants are consistently looking at these four historical sources when they're available and likely to be useful. They're all looking at aerials, topos, fire insurance maps, and city directories. And that was consistent whether the consultants were ordering the data packages and the historical packages from their data providers, or whether they were doing their own independent historical research and going to the library and looking at fire insurance maps and city directories and getting their aerials online. It didn't matter what their source of information was. Consistently, the bulk of environmental professionals were consistently looking at these four sources where available and likely to be useful. So the standard says that's what you need to do. That's what you should do. And if you don't, you must say why. And some very good examples that had come in, right? Aerial photographs show and interview information, document the property was residential and until this time, and then the office building was built. Okay, well, you don't have to go look at city directories to get tenants' names and everybody who lived in that house. You just say why. And then additional resources, those 8, right? Additional standard resources shall be reviewed if needed to satisfy the objective. And remember, the objective is, what was the historical use? Don't just tell your client that there was a building on the property. That's not use. Okay, then that was pretty straightforward. You could still use some of the other historical sources, and there was a list. They updated some, I got this here and I've used this there, so there's a nice list in other, but those aren't required to meet the standard. And there wasn't really much very controversial about that. This was pretty consistent with what most people were doing. Where it got challenging was what is good commercial and customary use for researching historical uses of adjoining properties. And again, we did a lot of industry outreach, talked to a lot of environmental professionals. Hundreds of data points came back to the task group on this particular issue. And they said the same thing. If I'm looking at those 4 historical sources, I'm looking at them for the adjoining properties as well. We had some environmental professionals that we were seeing a lot of difference in interpretation. And again, when people were looking to cut costs, this is where it would happen, is minimizing the research of adjoining properties. But I want to point out, and I encourage you to look at the current language in the surrounding properties historical section of the standard 2013 and all of them before. There was no specific discussion about adjoining properties. It just was subject property and then surrounding area. But we as a task group were looking at, what does it say right now? And in looking at surrounding areas, one of the pieces in the surrounding area says the time and factors to consider in what research you do is the time and cost involved in reviewing surrounding uses. For example, reviewing local city directories for more than a few streets that surround your site is typically too time consuming. For more than a few streets, that's what's in your 2013 version right now. The task group has always figured you were looking next door, right? So because it was the city directories that were the biggest debate. And so what the new historical section says for adjoining properties, it says, during your research for the subject property, past uses of adjoining properties that are obvious shall be identified to evaluate if those have led to wrecks. If researched for the subject property and they provide coverage for adjoining properties and they're likely to be useful in satisfying your objectives, you got to look at the same four. That's what people are doing. And again, you're looking at aerials, fire insurance maps, and topos. That's easy. Your site, your adjoining properties, you see it all. The biggest debate was over city directories, but just sharing with y'all, most of the consultants, that's what they're doing. All your, maybe not all the adjoining properties. If you don't, you just say why, right? You just say why. And there were some really good examples, like next door and downgrade down the hill and down gradient, or it's all office buildings. There were reasons, and they're valid reasons, and that's fine. So the standard acknowledges that if these four sources were reviewed for the subject property and not for the adjoining properties, you just say why. And then, of course, additional standard historical sources should be reviewed if warranted to satisfy the objectives, right? So from here forward, we need to be accountable for these four, the big four. We either reviewed them or we didn't. You just got to say that in all of the reports, you need to be accountable for these four historical resources, and then add any others that have been helpful in identifying uses of the subject property and adjoining properties. And there was story after story after story of adjoining properties that information, that historical information, easy to find, that got missed, that led to significant impacts to the subject property, or were part of the subject property in the past. The historical research for the surrounding area is pretty much unchanged, right? Still says the same thing that it used to say. We didn't want it. There was no need to change anything significant in the surrounding area historical research. We do have a new definition for significant data gap. That one's been a real challenge because, arguably we're going to have data gaps in every phase one report we do, right? There's not enough time or money to operate in a world of perfect information. We need to gather enough information to form our opinions, to reach our conclusions. But what was a significant data gap? What do we consider a significant data gap? At what point does it begin to affect our ability to identify recognized environmental conditions? So we've always been required, well, the 2013, because this came out of the all appropriate inquiries, that we were required to identify significant data gaps affecting our ability to identify wrecks, which is fine, but what do you do with that? And where does it go in your report? Because if you have a significant data gap, if you have a data gap so big that it's affecting your ability to identify recognized environmental conditions, then your conclusions are conditional on that data gap. And users didn't want to have to go hunt that down. So we have a definition for significant data gap, and that is a data gap that affects your ability to identify wrecks, right? That's the big hole. So you can have data gaps, but is it a significant data gap? And it's only a significant data gap if it's affecting your ability to identify wrecks. And then in the report, what the users, at the request of the users, your conclusion section now must identify wrecks, controlled wrecks, which are a subset of wrecks anyway, and significant data gaps. So arguably now we have better instruction on what to do with these significant data gaps. You can have a no wreck conclusion, but you got this significant data gap, so there might be conditions there that you're not aware of at the time, right? We just weren't sure how to make that all happen. And I think now it's going to be a bit more clear on how we can articulate this to the clients. And then, of course, the emerging contaminants, right? Most of you are very well aware of this whole polyfluoroalkyl substance and all of the other constituents related to this. And we couldn't talk about identify it specifically, right? PFAS today, who knows what in 8 years when this comes around again. But the whole concept of emerging contaminants is, this is going to be an ongoing thing because there's more coming. So we addressed it in a few different ways. First of all, under a non-scope, because remember, this is a tool. This 1527 is a tool for CERCLA landowner liability protections. This protects a buyer from EPA's cost recovery efforts when they spend federal dollars on a site that is a Superfund site, right? So, but these constituents, they're not CERCLA hazardous substances yet, but it's coming. It's coming, but right at this moment, they're not CERCLA hazardous substances. So technically they fall outside the scope of a CERCLA landowner liability protection tool, right? Now they're coming, and these PFAS sites are going to become Superfund sites down the road. This is the protection for a transaction that happens today. So we have some additional discussion in the appendix on our non-scope consideration that talks specifically as these constituents as an example, but also look to section 1, because in section 1 of the current and prior standards, I want to say it's 1.4 or maybe 1.1.4. I got my numbers mixed up sometimes. There's a section in there on other state, federal, or local regulations that you may need to be aware of, that the user may need to be aware of. And the user is encouraged to have discussion with the environmental professional about expanding the scope to include these emerging contaminants that are regulated in other ways. Because keep in mind, once these emerging contaminants are defined as a hazardous substance under CERCLA, they get brought in right away into the scope. They come under the umbrella at that time. So this is just a moving target. And again, this is intended to be a protection piece for environmental professionals and for buyers of properties that might be impacted with substances that are not yet regulated under CERCLA. But it's coming, so it's important to have these protections in place, having a proper, all appropriate inquiries done prior to acquisition. Then strengthening the deliverable, I mentioned we have, first of all, we have consistent use of the term subject property, because consultants, we were calling the property all kinds of things, subject property or site or target property, or there were lots of different ways. So the task group came to consensus that we're going to be consistent and we're going to call it the subject property, which is defined as the property that is the subject of the assessment. The users wanted more robust discussion about how significant data gaps are affecting the environmental professional's opinion. So you've got to have significant data gaps in your findings and opinions section, but also that gets pulled down. If you've got a significant data gap affecting your ability to identify RECs, it's got to be in your conclusion section of your report as well. And another thing that was very interesting, there's never been anything in the standard that said you have to have pictures or a map. And this again came from the user community, because they'd get these bargain basement phase ones that someone went out and bought, and they were horrifically done. They were terrible. And so the user groups would say, can you get me some pictures or make me a site map so I can see what you were looking at and where you were? And consultants honestly were saying back, that's an additional service. It's not required by the standard. Who knew we had to tell people you need to have maps and a photograph, and you need to have photographs and a map? So the standard now says you shall have photographs and maps, and photographs specifically that are relevant to recognized environmental conditions and de minimis conditions. Your users deserve that. So just some final thoughts on changes to the 1527, and I want to emphasize this. The latest revisions reflect input from across the country, from users and producers, and this input that represents good commercial and customary practice that's intended to result in a consistent quality deliverable. So environmental professionals that are already doing this consistent with what most of the environmental professionals told us they were doing, you're doing what your colleagues are doing, right? So you're not going to see much substantive change in your process, in maybe in the structure of your reports, but your process, if you're doing good reports now, this isn't going to be a big change to you. I've heard consultants say, okay, yeah, well, that's what I do anyway, right? If you're not doing this, you need to know that you are not providing environmental due diligence consistent with good commercial and customary practice, and you got to up your game. The other thing that I will say, as I'd mentioned, read the standard. Don't let the red line scare you, but read the standard and gauge the standard to what you're currently doing, and see where you might need to shift things around or do things a little bit differently. You might want to double check and confirm that your reports are currently conforming with the current standard. Remember what I said about it's reviewing city directories for more than a few streets beyond the subject property. That's already in the standard, right? So things like that are good to just, if some of this is like, it makes you nervous, some that I shared with you or what's in the new standard, is make sure that's a good time to go back and look at the red line and see if there was anything that changed in that area where you're concerned. Then I would also just say to consider joining the ASTM committee when we re-up this the next time. There's already people that are making lists of things they want us to look at when we open her back up for more discussions. And when will the 152721 affect me? I get that, and that's a common question for all of us. Right now, the 152713 is the one that's recognized by EPA as being conforming with the AAI. If you are doing brownfields work, and really, I think just in general, we need to continue referencing the 152713 for right now, because that's the one that is cited in the rule. So EPA is updating their reference, and it may, from the time we submitted the notification in November, the EPA told us then it could take a year or so to get through their process, and that's consistent with the 2013 process as well. So that's not unusual. So here are some options, and some of you are already doing it. That early poll, you might just use the 152713 until EPA gets their part done. And that's one option. But the 152721, remember, we've gauged it across the country, and that is a process that reflects good commercial customary practice. You could just transition entirely to 152721, and some have done that. But because the 2013 is the one that's cited by the EPA rule right now, I'm a little hesitant to suggest a universal adoption over to 152721. So one of the things that I'm suggested, and this is just the world according to Julie, is to continue citing the 152713. So you've got that T crossed and that little I dotted, but also add a note. Just add a note that says, and this assessment incorporates the updated procedures set forth in 152721, or something like that, that relays to your customer base that, yeah, we're still meeting the 152713, but just so you know, we're part of that good commercial customary practice, and we are already doing what's the additional rigor that meets the 152721. So those are my thoughts on what how you might want to approach what to do in this interim until the EPA reference is complete to 152721. One of the pieces of argument, one of the most common comment that came back to EPA was a request or a suggestion to remove the reference to the 05 or to the 2013 standards, so that the industry all moves consistently forward with the new standard. And there's a couple of challenges with that. There's nothing we did in 152721 and nothing EPA has done that makes 152713 not compliant with the regulation, right? I mean, there's nothing that makes that not compliant, except that the 2013 no longer represents good commercial customary practice. And that's going to be the legal challenge when these things go bad, and they go bad. So that's going to be the challenge. So if you're not incorporating 152721 already, arguably you're not performing all appropriate inquiries consistent with good commercial customary practice. So we'll see where all that lands. Those are my thoughts. That's the background on how we got here and my thoughts on what to do in this interim and moving forward. Dan, I see that we have a few Q&A. You want to help me out with some of that?
Absolutely. And prior to that, we have a couple of quick poll questions that we just want to throw out there in addition to the which standard are you using? And thank you very much for addressing that at the end of the presentation. So you'll see a poll question pop up here in just a moment. And all right, so using E15721, do you anticipate increased turnaround times? There was a character limit so for clarity of the question, do you anticipate increased turnaround times?
That's a really good question too, Dan, because one of our focus groups, and we had maybe 24 or more focus groups, turnaround time was something that one of our focus groups specifically had looked at. And it really had more to do with the agency file reviews from 2013. And just so everyone knows, we did revisit that issue, and it's all over the board depending on where you are and what part of the country you're in and what your regulator's response time is, as to whether or not they needed more and in some cases less time. And there was just no consistency or agreement on changing that 20 calendar day turnaround time. So we just left it as is.
Very good. We'll give each other just a moment here, but it looks like we have about 19% as increasing turnaround times, 73% remaining the same, which makes sense here. And I'm not sure being 8% because we're trying to help educate them here. All right, the second question is going to be in tandem with a question that came through the Q&A box in terms of, and I'll read the quote exactly. Are we increasing pricing as a collective? We should be, was the comment in Q&A, but I'm interested in everyone's opinion on this one. We have a battle going on with remain the same and increase, right. It looks like.
Yeah.
It's
and we've had this conversation, and we have to be careful at ASTM, because we have trade restriction requirements and stuff like that. But what in your world has not gone up in price? And literally, what is it that is compelling environmental professionals to say that they got to eat this stuff? We're our own worst enemies sometimes, folks.
Right. All right.
I actually have the
Yeah.
Q&A sitting up here. Do you mind if I go ahead and go through some of these and
Sure,
answer some of these questions? All right.
Absolutely.
So first question, can you give an example of what is a likely release? Okay. So a likely release, right? Historical research, dry cleaner operated from the 1940s to the 1960s, 1970s. You have no documentation of a release. You have no firsthand information about management practices. No regulatory oversight. You have no information. The only thing you know is that it was a dry cleaner for 25 years. And I can tell you that from the industry outreach that we did and the information we got back as a task group, your answer to that, you have a 88%, that is likely. An old gas station, something, whatever. If the question we have to ask ourselves as environmental professionals, if I were to go sample that site, am I likely to find contamination? So at the end of the day, it's going to be a gut check. Let's see, another question that came in regarding CREX. Oh, good question. Can I speak more about how tight the control has to be? And that is such a good question. And it goes on to say, for example, you have a site that was cleaned up to commercial standards, but it doesn't meet residential. But there's no formal AUL, IC, or EC filed. Right? Exactly. And that's why we developed the property use limitation definition. If you have residual contamination that has reached its risk-based endpoint, So nothing more needs to be done. No regulators making them do more. They got their NFA, or maybe they did a self-directed cleanup and they adopted what the agency has adopted for risk-based cleanup. You have a CREC. And that's exactly the point. You don't have, so maybe we have a formal AUL, maybe we have an institutional control or an engineering control filed, but not all the time. And I would argue not very often. We're getting better about that. But even today, we still have risk-based sites that are achieving a risk-based closure, and you don't have the formal AUL, institutional control or engineering control of record. And those are the ones that are getting missed. That is exactly the problem we were trying to resolve as a task group. You've got to capture those as a controlled rec, because a buyer has to know we need to know what it is, where it is, and what the control is. And if it's just simply that you remain commercial, that's fine, right? You know that, but that's the control. So I hope that answered the question. And that is exactly the problem that we were addressing. Question in here in relation to HRECs. What about a release that occurred off-site, but it may have migrated to the site? Okay, right? Then it's affecting the subject property. So when I say we're only concerned about the site, remember what I'm saying. We're concerned about what's affecting the property. So if you have a site across the street or anywhere, and you think or you know that it's migrated onto the site, that's the rec. Now, with respect to HRECs, you're talking about a historical rec. There's been a release. It affected your property. It's migrated onto your property. And you now have data that shows that it meets unrestricted use criteria, right? That would be an HREC. If you're using historical rec to say there was a past release that might have migrated onto my property, but you don't know, but you think it might have migrated onto my property, that's your rec. Presence or likely presence of the contamination on your property. That's why we're looking at offsite potential sources to your property. My point is if you have a risk-based, if you have a closure for the leaking underground storage tank next door, and it never affected your property, it certainly is a finding, but the rec was never there in the first place. That's what I mean, is we're concerned about what is affecting the subject property. So look at that phrase in the HREC and the CREC definition, and I hope that clarifies that. Let's see, how do you determine the past uses of a retail building if there are no city directories or lack of information from the owner? That's an interesting question, and that is a regular problem. So I would say, look at some of the other historical sources, look at perhaps building department records, anything that can help you get some specific information on the tenants that are in the retail building. All right, so what do you do about that if you've got nothing and all you know is there's a strip center and you have no other information? You might want to consider that as a significant data gap. Pull that down into your findings and into your conclusion section. Deal with it as a significant data gap. We've had it happen, so I understand your pain. And that's the beauty of the change that we made in the standard this time, is that previously you kind of had to make a call on that significant data gap, rec or no rec. The way the standard is now structured, you can reach your conclusion with the information that you have, and you can then also document, but I've got this significant data gap and my conclusions are conditional on what I don't know. Okay, for adjoining properties, regarding if they provide coverage, does that mean you have to order aerials in such a way that you are definitely getting adjoining, or you can just order as you would, and if they're there, if not, they're not? Yeah, that's so for aerial photographs, especially for a relatively small piece of property, you need to be, so the data providers will give you aerial photographs that have your property and your surrounding properties. It gets different when you're on really huge rural properties, and you can look to the 2247 for guidance there. the mistake that I often see consultants make is they order their aerial photographs from the data providers and they just drop that in the report as it's given to them. And you need to do some QCing and use the environmental professional thinking cap and scale it. You can scale the aerial images that you get appropriately so that you capture your adjoining properties. Again, huge, large, rural, big, linear corridors, things change when things start stepping outside of the traditional commercial real estate. But for your aerial photographs, there's no reason you shouldn't be on a traditional commercial real estate transaction. Yet there's no valid reason why you would not be looking at adjoining properties with the same picture. Let's see, is it required to use the term subject property? Yeah, to be consistent with the standard, let's get consistency. Yeah, use subject property. If you choose, remember though, the standard allows you to deviate from the standard. The standard does allow deviations, you just state it. So if you're really intent on using your specific word for your site and that's what you're gonna do, I would just call it out as a deviation in the standard that for the purposes of this assessment, we're going to use the term site rather than subject property, because the standard does say subject property. So if you're going to change it, if you're going to deviate it, just document that in your report. Let's see, next one. Are we increasing our pricing now as a collective? We should be. So I can't answer that question directly, except what I said earlier. Why are we feeling that we're the only industry around that cannot have our pricing accurately reflect the professional services that we are providing? And especially when you ask about increasing pricing, if your firm is not doing what the standard now says needs to be done, then yeah, you got to up your game. You got to increase what you need to improve what you're doing, and along with that will be should be the appropriate adjustment in your pricing. Let's see, when is the expected date of the new standard going to be issued? So the new standard's already issued. The new standard came out November of 2021, so it's out. And it is available on ASTM.org. Just Google 1527-21 ASTM.org and you'll find it. So it's already out. Oh, thank you. A very nice comment saying, thank you, I appreciate the feedback. If a subject property is bounded on all sides by roadways, will the adjoining properties be considered the roadway or the properties beyond it? All right, so go to the definition of adjoining properties in section 3. And this has not changed, and this has always been the case. Adjoining property, and again, you can use this language in your standard if you need to articulate this to your clients. Adjoining properties are contiguous or partially contiguous or would be contiguous or partially contiguous if not for the presence of a roadway, public or other public thoroughfare. So that's always been the case. It's what's across the road is your adjoining property. Across the intersection, that's your adjoining property. Where that gets challenging is in the historical research, and that's that roadway, that 6-lane highway didn't used to be a 6-lane highway. What's under the highway used to be adjoining. So the historical research section has been updated to reflect that you need to be thoughtful about those changes. Let's see, where am I? Do all gas stations and dry cleaners constitute a wreck? Let me put it this way. Things are not wrecks. A tank is not a wreck. A dry cleaner is not a wreck. A gas station is not a wreck. The likely release affecting, it's about the release, the likely release from any of these things, that's the wreck. The likely release affecting the subject property, that is the wreck. So you could have a dry cleaner down the hill, down the road. You may decide there's not a likelihood that that release would come back your way. But here's a broader question. Are all dry cleaners on your site? Are all gas stations on your subject property a wreck? And again, things are not recs. They are findings. And then you overlay your other professional opinions. Gas stations especially, it depends, right? Because they're regulated, they have double walled tanks and continuous monitoring and cathodic protection and whatever it is and they have tank tightness testing on a regular basis. So you're going to have to make that determination on your gas stations. Dry cleaners, what's the likelihood of a release from a dry cleaner on your property? And I just shared it with you. 88% of all current active dry cleaners. And I was just part of a panel just a few weeks ago. Most of them are still using PERC, and a whole bunch of them are still using old models of machines because it's incredibly expensive to upgrade their machinery. This PCE problem, this PERC problem from dry cleaners is going to be with us for a really long time. The likelihood of a release from a dry cleaner on your property is very high, and in my opinion, would be a wreck. Let's see. If the standard is purchased and there are changes made as a result of EPA review, will the revised version be sent out to people who have purchased it? There won't be changes. That's not EPA's role. There won't be changes as a result of EPA's review. That's not, they participated in our task group and offered some input at the time that we were developing the revisions to the standard. Their role is a simple yes or no. It is compliant or it is not compliant. And they've already said it's compliant, so that's already done. So there will not be changes to the standard as a result of what EPA is doing right now. If for some reason they choose not to adopt or not to reference the 1527-21, well, then we're back as a task group and reopening things up, and you'll see something different in a few years. But I don't see that happening. Let's see. When a related contamination site is closed with no restrictions, but it is obvious that contamination is present above cleanup objectives, like the agency didn't follow their own rules, would that be called a CREC or an HREC? That's a good question. So environmental professional judgment is going to come into play here. And we've had that happen. And I would say it's either going to be, well, and again, world according to Julie, I'm just giving you my opinion, reflective of some of the things we've encountered. It's a wreck until we get it figured out. Let's see. You reference your industry research on dry cleaners have an 88%, not 88% chance. It was 88% result. Can you point us to that reference? And are there other references out there for scenarios of USTs for sure? So API, the American Petroleum Institute, might have some of that data for underground storage tanks because we dealt with that many years ago. So I can't give you a current reference. I do have the reference for the dry cleaner fund. It's actually a link for their study, and it was a while back. But Dan, I can probably get that to you so that anybody who asks for it, I can give them that information. It's part of my task group stuff.
Wonderful, thank you.
And you can, again, you can look to SBA. That's another reference is what they require for anything that has a dry cleaner. But I don't think they have, other than their SOP, I don't think they have anything else that's published. What is your typical recommendation for non-gen dry cleaners now that you think of them differently? Good question, because I've seen a lot of consultants get this wrong. So dry cleaners that come up as a non-gen, there's only one way they get to be there. The only way you get to be on a RCRA non-generator database listing is if you were a generator in the first place. And there's so much litigation all across the country where consultants have incorrectly seen a RCRA non-generator for dry cleaners, therefore you're only a drop-off location. That was just today. And they're on that list because they used to do dry cleaning at that site. And I have personally, I have walked into half a dozen non-gen dry cleaners in my area where a phase 1 said non-gen, drop off only, and the dry cleaner machines were still in the storage room. So yeah, Just because they're a non-gen today, they were a generator before. Go look. Just a couple of, can we go keep going, or do we have a hard stop here? Do we need to stop?
So we don't have a hard stop. Of course, we're conscious of everyone's time. We'll be sending out the recording. So
Yeah.
if we're open, we can continue. If not, we can follow up with some questions offline. It's up
All
to
right,
you.
let me hit a couple of these others. Pesticides, herbicides, insecticides. To what degree is the EP expected to be an expert on that? That was not addressed in this task group. So I don't really, so for the purposes of what we're talking about today, I don't have an answer for you on that because we just didn't address it. Let me point you to the legal appendix where there's discussions on the application of herbicides and pesticides versus a release, and take a look at that. But beyond that, I would say know your general area and where that tends to be a problem. I come from alfalfa field territory, so we don't have the tobacco farms and some of the other things that you guys have in other areas. Ever since COVID, state agency response times for file requests have been all over the board. Yeah, remember I told you we had a focus group looking at specifically that issue. In so many cases, we assume file information will not be available within the designated turnaround time. If our review of the database report and professional experience suggests an offsite release can be dismissed, how beholden are we to pursue the file request in the first place? I can only share with you that there's a lot of litigation because the consultant didn't even try. Just be careful. Just be careful. Better to try. At least put the request in and say that you tried, and then deal with it as a data gap. That would be the better thing to do. And then use your professional judgment, right? But at least show that you tried. With respect to the earlier question regarding a release at an adjoining property, what would you do if the adjoining release was likely to have migrated on the subject property, but was sampled next door to be below unrestricted use? Well, so this is where your environmental professional judgment comes in. You know, where were the sample locations? What is the gradient? How close was it to your property? If it's non-detect on the adjoining property, you must have a reason why you think maybe it wasn't in the right location, or the gradient is different and it didn't answer the question. So that's your professional, that's the expertise you're bringing to the table for the transaction. To clarify, chain of title is not required, and it never has been required. Chain of title is not required as a standard historical source, but must be considered for the subject property if missing any of the 4 required sources. Nope, 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 not at all. You have 8 standard historical sources. Chain of title is not one of them. It's an option. If you think it will be useful, you can certainly use it, but it's not required. None of them are particularly, even of the 8 are not required. That you use your professional judgment. And here was the challenge. The standard has said, here are these 8 standard historical sources. Environmental professional, you're the smart one. You know your site in your area. All sites are different. Use your professional judgment, and you only have to review as many as are necessary to achieve the objective. And the unfortunate thing is that there is this bottom tier of consultants that had taken the word only incredibly seriously. And they did absolutely minimalistic work and with very egregious outcomes and some real problems with that. So 2 things we did. We removed the word only. We need to not imply minimalistic work is okay here, because it's not. And then gauged what everybody's doing, and they're at least trying to get those 4 sources where they're available and likely to be useful. But you have the options to use other sources, but there's no specific requirement for chain of title. Let's see. Does the committee realize that the near future may involve remote site reconnaissance? This current edition does not seem to anticipate that reality. That's not in the near future. Man, that was COVID, right? We had to figure out how to get through that with COVID. And 2247 is also talks a lot about remote sensing, but still, even then, physical boots on the ground is an important requirement of the standard. Now, if you can't, for whatever reason, then you deal with that as a data gap, and you cite the sources you consulted to address the data gap. And in COVID, some of that was happening, right? A property owner was doing some real-time FaceTiming getting into boiler rooms and important areas so that they can satisfy the site reconnaissance. And you just describe that in your report, that reality in your report. But hands down, both the 1527 and the 2247 have said boots on the ground, visual, you got to see it, is a required part of the standard. You just document limitations or deviations if for some reason that can't happen. When do you anticipate the EPA referencing the 1527 standard? Yeah, so I'm hopeful that they'll be able to get that done by the end of this year. And I know that that's what she's trying to do. Like I said, there are just some things that are out of her hands. On the when will the 1527 affect me? If one transitions fully to 1527-21, can you expand on how it's current and customary practice if it does not yet meet AAI or have EPA's blessing? Okay, so those are two different questions. What the standard reflects is good commercial customary practice. And that's an important phrase that's in federal legislation and in all appropriate inquiries regulation. So we're in this interim right now waiting for EPA's blessing, right? So, and I understand holding off changing to the 2021 until EPA approves it. I get it. And that's one of the options. But as I said, two reasons, because you asked, let's see, we've been holding off until EPA approves, especially for clients that are in an acquisition, and that's fine. Wouldn't we be remiss for using 2021 before EPA approves it? Personally, I think we need to continue referencing the 1527-13 because of that reference. Functionally, and as a service to my clients, I want my client base to know that we already meet that rigor that is reflected in 1527-21. And that's why I was suggesting one of the options that I've seen used effectively, and we're doing it as well, is reference to 1527-13 and just add a little note that says, and it also meets the additional rigor set forth in 1527-21 or however it is. So right now, so there's no harm in referencing both. I see downside to referencing only one or only the other. I don't see any downside to referencing both. Can we use the language to address environmentally sensitive industries only for adjoining properties? This particularly applies to dense urban areas. Yeah, you know, you're using professional judgment and you're explaining, and really what the user community wanted was explanation, communication. Tell them what you did and tell them what you didn't do and why you didn't do that. And then they can decide if they want to get some additional something else done. They just want communication. Regarding the adjoining property question, would a river count the same as a road? I love that question. I use that in classes, right? Is a river a public thoroughfare? And that's an interesting question because that's been litigated. From my perspective, I'm thinking remember, it's uses. And so from my perspective, I generally will consider property across the river as the adjoining property. But when you think technically about the definition of adjoining property, the question that comes to mind is the river a public thoroughfare? It's an interesting question. And rivers move, by the way, and banks move, and oxbows move. And so lots of things to consider with rivers. Does likely release have to result in constituents above regulatory standards to be considered a REC, right? Yeah, I mean, otherwise it's de minimis, right? If you have a release that never, a tank where you got your samples and all your confirmation samples show less than, meeting under, you got something, but it meets unrestricted use. Yeah, that wouldn't be a REC. I would like that link. Okay, I'll try to get that. If our state agency regulates PFAS, PFOA, how does that play into emerging contaminants? Again, look at section 1. There is a section about that, and it's in 2013 as well, just more robust this time. And look at section 1 0.1.4 or 1.4. It's somewhere, you'll see it. Things regulated at federal, state, local levels. And there's a discussion in that section and some expansion in that footnote. So I would say look to that to help guide you on what's expected. I have to run to a meeting. Oh, very good. Thank you. Appreciate the feedback. If purchasing 21 from ASTM or website, what's the difference between the PDF version and the online standard red line bundle? I don't know. I have no idea. You can send a question into ASTM. They'll be happy to help you, but I don't really know the difference. All right, that's the last one.
Wonderful. Well, thank you very much, Julie, for an informative presentation. We really appreciate it. Big thanks from all of us at EnviroSite for those that attended. We had some great interactions, great questions, so we really appreciate it. If there are any questions that weren't answered, feel free to reach out and/or we will address those offline. And that concludes our webinar. Thank you so much, everyone, and enjoy the rest of your day.
Bye, everybody. Thank you,
Thank you.
Dan. Bye, Brett.
Take care.
Thank you, Julie.